Hello, my name is Susan and I'm one of the solicitors here at Clarity Simplicity. Today I'm going to chat about the importance of having a will and a power of attorney in place. Many people don't like to think about these things and will put off getting the necessary arrangements in place. However, for the following reasons, it makes sense to make a will and to grant a power of attorney. Firstly, what is the difference between the two? A will is something you make to leave instructions about what you want to happen to your assets after you die. A power of attorney is a deed in which you authorise someone else to make decisions for you when you are not in a position to make decisions yourself. For example, due to having been injured in an accident or having a condition such as dementia. Why is a will important? In your will, you appoint the person or persons you want to deal with your estate after your death, your executors. If you don't have a will, the law sets out who can be appointed and an application to the court is required for an executor to be appointed. This is something which will delay the administration of your estate and which will cost money paid for out of the assets in your estate. It can lead to arguments between family members about who should be appointed. Only an executor has the authority to deal with your estate. If you die without a will, your estate is called an intestate estate. The law sets out which person or persons an intestate estate should go to and how much each person should receive, rather than you having made those decisions yourself in advance. The applicable rules are called the rules of intestacy. The rules are complex and difficult to understand and can create confusion for the family at an already difficult time. There are certain classes of family members who have a claim on your estate regardless of whether or not you have left a will, namely a spouse, civil partner and your children. However, what they are entitled to claim if you leave a will is different to what they are entitled to if there is no will. Not having a will could also have tax consequences on your estate. If you die without a will and have no family, your estate will go to the Crown. It is often necessary to apply to the court for confirmation of a deceased person's estate. You may have heard this being referred to as probate, which is the equivalent of confirmation in England. Only an executor can apply for confirmation, and if there is no will, the executor must apply for a special insurance policy called a bond of vacation before confirmation can be obtained. The cost of the bond will come out of your estate. Moving on to power of attorney, why is it important? If something happens to you which means that you are not capable of making decisions in relation to your affairs, and you do not have a power of attorney in place, there is no one who has authority to make decisions for you. These decisions might be in relation to medical treatment, where you should live, and decisions in relation to financial matters, for example. In that situation, if there are decisions which need to be made, someone will require to apply to the court for a guardianship order to be granted. This is an application in which the applicant is asking the court to appoint him or her as guardian and to give authority to make decisions on the incapable person's behalf. Such an application is time-consuming and can be very costly. For the person who is applying, it can be very stressful. There could be disputes between family members about who should be appointed as guardian, causing a lot of distress and upset for all involved. The law states that specific reports need to be obtained to submit with an application for guardianship. This will involve a mental health officer looking into the incapable person's circumstances and the circumstances of the person who is applying to be appointed. The court, when granting a guardianship application, can only grant it for a specified period of time, which means that before the guardianship order expires, the guardian will need to make another application to the court for it to be renewed. Here at Clarity Simplicity, we can assist you with making a will and putting a power of attorney in place. If required, we can also refer you to a third-party advisor, for example, for advice about tax. Please just call us or contact us via our website to arrange an appointment with one of our friendly team.